Okay, good afternoon, good morning, good evening, whenever you're watching and listening to this. Welcome back. Today we're going to be talking about contract law. This is a rather long segment because it contains a chapter full of many aspects that all relate to common law contract law. A contract is a promise or set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes a duty. Now, the source of that definition is Restatement Second of Contracts. Contracts are agreements to do something or not to do something at a future point. Contracts are forward-looking in nature. If the contractual promise is not fulfilled, a legal remedy can be pursued. A contract is never past-looking, if you will, or something that occurred in the past. It's always going to be future-oriented. There's a theory of contracts called the objective theory. Contracts are viewed from the perspective of an objective third party. They are not defined by the personal or the subjective intent or belief or perception of a party. The facts are interpreted by a reasonable person standard. Let's talk about elements for a binding contract. Now, in your textbook, there are 4 elements because your authors blend together the first element of offer and acceptance into the agreement element. I'm going to break that down even further and list 5 requirements for a contract to be legally binding. That would be an offer, acceptance, consideration, contractual capacity, and legal objective or acceptable legal purpose. An agreement, and you've often heard the term agreement, to form a contract includes an offer and an acceptance. So when you hear of the term agreement used, that means there has been an offer and the offer has been accepted. And there is an agreement. But an agreement does not mean that there is a legally binding common law contract. One party must offer to enter into a legal agreement and another party must accept the terms of that offer. And once all the other elements to the contract are present, then there will be a binding contract that is recognized. Consideration, which is an element required for a binding contract, is the exchange of promises wherein something of value is received or promised. A bargain for exchange of value results in consideration to bind the agreement. So when you have the agreement, that's present because there's an offer and an acceptance. The next required element is consideration to bind that offer and acceptance. Doesn't mean that once you have an offer and an acceptance and consideration is present that there will be a binding contract. It may lead to a binding contract, but all 5 elements must be present. Let's talk about the element of contractual capacity. Both parties entering into a contract must have the contractual capacity to contract. The law recognizes the parties as possessing characteristics that qualify them as competent parties. If there is no capacity to contract, then that element to the contract is absent and there's no binding contract. And then the last element is legal objective, legality. The purpose for the contract must be legally acceptable. For example, the objective of the contract, the purpose of the contract cannot be against or contrary to acceptable public policy. We'll talk about public policy in just a moment, but let's talk about different types of contracts And all this information is contained in your chapter within the textbook assigned. Contracts involve either an exchange of promises by the parties or a promise conditioned on the performance of an act. A unilateral contract is an agreement with only one promise, and only one party is committed to perform. The root word of unilateral is uni, which means one. A unilateral contract looks to performance by the offeree, and that's a term we'll talk about in just a moment, as the means for acceptance. As we have discussed so many times already in this course, terms are important. Terms that define the relationship between the parties and their obligations to each other are important for your understanding and to really have a good comprehension of this subject area. So when we use these terms, bilateral and unilateral contracts, as well as other terms that we'll get to in just a little while, they have meaning, and they have meaning in application to the relationship and obligations of the parties. A unilateral contract looks to performance as the means for acceptance. A bilateral contract is an agreement containing mutual promises. So the root of bilateral would be bi, meaning two. A promise for a promise results in a bilateral contract. When both parties have a duty to perform obligations they have promised to each other, there is a bilateral contract. When one party has the obligation to perform, that performance will result in the acceptance of the offer to form an agreement. Let me give you an example. Let's say that there are two people on opposite sides of a bridge. One person is Ann, the other person is Bob. If Ann says to Bob, I will pay you $10 to walk across this bridge to my side of the bridge, and Bob starts walking across the bridge, when does he accept that offer? When he gets to the other side of the bridge where Ann is located. Then she has the obligation to pay that which she offered, $10. What kind of a contract is that? That is a unilateral contract. When is performance measured? When he has crossed the bridge to the other side. That's acceptance. Acceptance of her offer to bind the contract, looking for his performance in the form of acceptance. Many contracts arise from interactions which the parties actually discuss the promised terms of their agreement. They are called express contracts. Again, another term. When there is negotiation captured in the form of memos, stated words of intentions, and other communication evidencing discussion of promised terms, there is an express contract. I want to go back just for a moment and give you the example of a bilateral contract as opposed to a unilateral contract when the same example occurs between Ann and Bob in that bridge. If Ann offers Bob $10 to walk across the bridge to her side of the bridge, and he agrees, and his agreement is signified by his verbal acceptance or written acceptance, then there is a bilateral contract. She then would be the offeror, he's the offeree, looking for performance as the measure of acceptance. In a unilateral contract, when there is a promise for a promise, their relationship becomes that of a promisor and promisee. Bob has promised to walk across the bridge to accept the $10. She has promised to pay $10 for him to walk across the bridge. They have a bilateral contract, assuming all of the other elements are present. The elements of consideration, capacity, and a legal objective. Let's talk about implied in fact contracts. Implied in fact contracts arise from the conduct, not the statement of words and terms of the parties. Implied in fact contracts are examined in the context of party circumstances. For example, asking a person such as an accountant for professional advice, as your authors indicate in your textbook, implies a promise to pay the going rate for this advice, even though you do not make an express promise to pay for it. So when we look at different types of contracts, there can be an oral express contract, there can be a written express contract, and there can also be an implied in fact contract. All of those forms of contract are all legal. They're all going to be enforced as long as all of the elements are present. The difference between an oral contract and an implied contract is one of evidentiary support. Obviously, when you have an express written contract, you can see the terms that have been promised between the parties, and those express terms can be evidence of their respective obligations to the other. Implied or oral contracts, they're just as legal, however, there must be evidence of the implication and evidence of the parties' oral or verbal assurances or promises. Enforcing implied in fact agreements is an important means of ensuring that one party does not secure the benefit of a contract without compensating the other party. Implied in fact agreements must contain the same elements as express contracts, including, as I just mentioned, acceptance and consideration, legal capacity, and of course a legal objective. Let's talk about a term, let's talk about a term called implied in law or quasi-contracts. Quasi-contracts are a judicial remedy, that's a remedy imposed by a court to prevent one party from receiving unjust enrichment at the expense of the other. Unjust enrichment means that one party has received the benefit of the bargain at the expense of the other without compensation or value remuneration. Let's go back to the earlier example of the accountant that was providing accounting advice. There is an implied understanding that when one calls upon an accountant to provide an opinion, advice about accounting or tax matters, that there is going to be some form of remuneration that will be provided, a reasonable fee. If the person who obtained that advice at the expense of the accountant without paying for that advice, the accountant may pursue a claim for implied in law or quasi-contract remedies. When one party is unjustly enriched at the expense of another, the law may impose a duty on the first party to pay the second, even though there is no contract actually in existence between the two parties. This doctrine requires the result be implied in law, hence the implied in law contract. Since there's no actual contract agreement, the term quasi-contract is used. And again, your textbook has much more information on these various aspects. The purpose of this slide presentation, this PowerPoint presentation, and my narrative is just to highlight aspects in your chapter that ought to be understood. A quasi-contract applies only when there is no actual contract to enforce. It is a judicial remedy to prevent injustice when one party has taken advantage of the other. Let's talk about more terminology, more contract enforcement terminology. A valid contract is enforceable. What's required for there to be a valid contract? The answer is satisfaction of all the required elements to form a contract. So when you hear the term valid contract or enforceable contract, it means that all of the terms are available and have been satisfied. Void contracts are unenforceable. They're not going to be upheld. Voidable contracts, that's another term, voidable contracts are enforceable with the right to do so when a party elects to void the contract. And we'll talk about this in just a moment, but voidable contracts may become valid and acceptable, or they may become void at the election of a party to do so. A void contract never was a contract from the outset because one or more of the elements was missing. Let's talk about that in more detail. A voidable contract is when one party has the right to withdraw from the promise made to the other party without incurring any legal liability or the possibility for damages. That party has the power or the capacity that the law recognizes to end the enforcement of a so-called voidable contract. An example of a voidable contract is when a minor enters into a contract. The minor is someone who has not yet attained the age of majority. In most states, the age of majority is age 18. Technically, a minor in the eyes of the law is an infant. And the law is very protective of minors or infants and will recognize that level of protection up until that minor attains the age of majority and in some circumstances within a reasonable time thereafter. That minor has the right to withdraw from the contract that was made during the time of minority until attaining the age of majority or a reasonable time thereafter as the circumstances may warrant. A valid contract, and again, this is for purposes of terminology and recognition of what is required to have a contract, is when all of the elements of a contract have been established or satisfied. A void contract, and you need to know the difference, is when one or more of the contract elements is deficient or missing. When that occurs, there was never any contract to begin with. It was void. Let's talk about more terms. An executed contract is one in which the parties have performed their promises. In other words, they've satisfied their obligations to each other as they have promised to do. When the parties have yet to perform their agreement, the contract is called an executory contract. Again, terminology, but these terms have meaning and they have application. So let's again talk about some terms and a little bit more detail, and we'll focus on contract formation. A bilateral contract is a promise for a promise. A unilateral contract is a promise for an act to be performed. In the example I used earlier, Ann promised to pay Bob $10 if Bob walked across the bridge to her side. His act of walking across the bridge constituted performance, which equaled acceptance. Once that acceptance occurred, then you have an agreement. And as long as there's consideration, capacity, and a recognized legal objective, that agreement can be enforced as a binding contract. Let's talk about a couple of other terms. a formal agreement requires some special form for creation. Today, very few contracts require formal recognition or some formal required aspect or form. The party of the first part agrees hereto with the party of the second part that in consideration heretofore there is a formal contract for which is accepted and legally binding upon the parties. That type of language signifies a formal agreement, which is not necessary. An informal agreement requires no special form for creation. It recognizes a contract possibility for enforcement as long as the elements have been satisfied. An express contract is a contract formed by words, written or spoken. An implied contract is formed by the conduct of the parties when examined in context. Usually the conduct of the parties is going to be taken into account when there has been past relations of that business kind with the parties. Some past course of conduct, some past course of performance, something that has historically been seen as repeated within a context that's similar. Every contract involves at least two parties. There can be multi-parties to a contract, but the minimum requirement is two parties. Again, let's talk about terms. Offeror is the party making the offer. The offeree is the party to whom the offer is made. A promisor in a bilateral contract is the person extending the promise. The promisee is the person receiving the promise. So again, terminology has meaning and application. And it also defines the role and expectations of the parties. An offer, and we're going to kind of break this down. We're going to go through an offer, we're going to go through acceptance, consideration, capacity, and objective, all in a little bit more detail in the next several minutes. An offer contains a specific promise for a specific commitment. Let me give you an example. I will pay $10,000 for your Ford Mustang. The offeror, that's the person making the offer, must intend to make the offer. By making a commitment to the offeree, that's the person to whom the offer is made. What's the commitment? To pay $10,000 for a specific Ford Mustang. That Mustang is owned by you or the person to whom the offer is extended or directed. So content, purpose, price, details. The offer must contain specific promises and a specific commitment to be enforceable. It must contain definite terms. I just mentioned that to some extent the terms of the offer must be definite. They must be certain. The terms must reflect the essence of the bargain with specific aspects. For example, the parties, the subject price, or the price, the subject, details. There has to be definite and complete terms to satisfy the requirements for the offer, which is one element for a binding contract to exist. Let's talk about termination of offers. If there's been an offer extended, how is the offer going to be terminated? Offers create a legal power that's extended to the offeree to accept the offeror's commitment in a contract. That legal power to bind does not last forever or indefinitely. Offers can be terminated by an explicit act of one of the parties. When the offeror retracts the offer before acceptance, there's a revocation of the offer. Can that happen? Yes, it may. Let me give you an example in a unilateral contract setting, and I'll use the same example that was mentioned earlier. Ann is on one side of the bridge. She's offering Bob $10 to walk across the bridge to her side. Bob starts walking across the bridge. More than halfway across the bridge, Ann communicates that the offer has been withdrawn and the offer has been revoked. How does she do that? She can say, I withdraw my offer. Bob, I'm not going to pay. The offer is off. Has he accepted the offer in that setting? The answer is no, if his walking across the bridge is seen as performance. How does an offeree perform in a unilateral contract? That is by way of performance. How is performance measured? When he completes that which was offered, namely to get to the other side of the bridge by walking to qualify for payment of $10. Does the offeror, Ann, in that setting have the right, the power to withdraw the offer prior to acceptance, which is performance? The answer is yes. Now, how could Bob have changed that scenario? He can create, by his authority as the offeree, a so-called binding bilateral contract, assuming that all the other elements are present. How does he do so? I accept, Ann, your offer. I am going to, right now, walk across the bridge for $10. In other words, he has communicated his acceptance by way of an expressed offer to perform. There has been then a bilateral contract, a promise for a promise. Can she withdraw the promise to pay $10 once he starts walking across that bridge and gets almost to the other end? The answer is no, because Bob has accepted the offer by way of his return promise. A promise for a promise is a bilateral contract. Another way that the offeree can reject the offer is by communicating that there's not going to be acceptance. So let's use the same example. Bob is offered by Ann $10 to walk across the bridge. He rejects the offer. He can do so verbally, in writing, or even by implication. He can simply walk off, ignore her, and that ignoring aspect rejects the offer. So the best way to communicate rejection, however, to avoid confusion would be, I'm not going to accept. So when the offeree rejects the offer, what happens to the offer? It is no longer capable of being accepted. It's now over. It's extinguished. When the offeror makes a counterproposal, I should really say the offeree. That's a typo there. It's the offeree makes a counterproposal. And I'm putting into parentheticals on your slide the mirror image rule. The mirror image rule is a common law contract requirement which indicates that for the offeree to accept, it must mirror the offer that was extended. The acceptance must mirror the offer which was extended. So let's say, for example, Ann offers Bob $10 to walk across that bridge. And Bob says, I'll walk across the bridge for $20. What happens then to the initial offer? It's been rejected by the counteroffer or counterproposal. That initial offer of $10 is no longer capable of being accepted because it's extinguished by Bob's counteroffer. Now, the mirror image rule says it has to mirror back the exact offer extended by the offeree. So if Bob says, I will offer in return for your $10 to run across the bridge, that's still, in a way, saying he'll get to one side of the bridge for the other, but what was the nature of the offer? To walk across the bridge for $10. If Bob runs across the bridge for $10, either without promising to do so, therein creating a unilateral contract, a bilateral contract, or if Bob simply runs across the bridge, has there been acceptance in a unilateral contract setting? The answer is no, because it does not mirror back the exact offer which was proposed. Other ways that offers can be extinguished would, of course, be if the contract is destroyed or the object of the contract is destroyed. So I guess using the example of the bridge, walking across in order to qualify for the extended offer or the promise to walk across the bridge, therein creating a bilateral contract. If the bridge is no longer in existence and it was destroyed, then obviously that contract cannot be performed. So the object of the offer, the subject matter, is destroyed, therein also extinguishes the offer. When the offeree fails to accept by a defined deadline date in the offer, or after a reasonable period of time, there is considered a lapse. And a lapse of time will also extinguish the offer. So let's say that Ann offers Bob $10 to walk across the bridge, but does not define a deadline date for which that offer is going to be applicable or open for acceptance. Let's assume that 2 years from now, 2 years from the time that that offer was extended, Bob walks across the bridge and therein decides to require Ann to pay the $10. Do you think that would be an acceptable, reasonable time to establish acceptance? The answer is no. No. Even though no deadline date was specified, that offer probably would expire based on a lapse of time. 2 years would be an undue lapse of time to expect there to be acceptance to that offer. Now, if the offer was extended at 2 o'clock in the afternoon and Bob walks across the bridge at 3 p.m., that's a different story. Again, context makes a difference, and reasonability has to be measured both in time and in setting. The offeror's death or insanity can also effectively extinguish or end the offer. And of course, subject matter illegality. What is meant by subject matter illegality? Well, the offer itself or the subject for which is being asked to accept is against public policy or against the law. Acceptance of an offer is necessary to create a valid, enforceable contract. And as mentioned earlier, unilateral contracts are accepted by performance of the requested act, not by making a return promise. Make sure you understand the difference between unilateral contracts and bilateral contracts and how in some situations the promise to accept therein creates a bilateral and binding contract insofar as the other elements are all satisfied. To create a binding contract under common law contract law, the acceptance, as I mentioned earlier, must mirror the offer. It must match the offer exactly. Silence is not accepted. An offeree's failure to reject an offer does not mean or imply acceptance. Let's talk about the mailbox rule. That's also referenced in your textbook. Unless the offeror specifies a particular time, the acceptance usually binds the party when the offeree dispatches it. Since the offeree usually mails the acceptance, and this was in the day when acceptance was most readily communicated by way of the Postal Service, the acceptance becomes binding when it is deposited with the Postal Service. Hence, the mailbox rule was created. Another term for the mailbox rule is the deposited acceptance rule. Now, the importance of the mailbox rule is that the offeror cannot revoke the offer once the offeree has accepted it. Now, think about that. The importance of the mailbox rule, or the deposited acceptance rule, is that once the offeror has communicated that offer and has not determined or specified the terms for which the offeree has the power to accept, that once that offeree deposits acceptance in a mailbox, then the offeree is considered to have accepted the offer. The mailbox rule does not apply to instantaneous forms of communication. As an example would be when the parties are dealing face-to-face, by telephone, by fax, by email, or by any other instant messaging, I suppose, today. Let's talk about consideration. Another element for a contract to be enforced is there must be valid consideration. There must be some incentive or inducement for a person's promise to be binding. Consideration is the receipt of a legal benefit or the suffering of a legal detriment. Courts will not enforce the contractual promises unless there is consideration that can be determined. Consideration need not be evidenced by money, but money, of course, is good evidence to view consideration. Valid consideration can include any promise to do something that one has no obligation to do, or refrain from doing something that one has no obligation, or in the case of a unilateral contract, a performance when there's no obligation to perform or to do so. Let's go back to my bridge example. Ann offers Bob $10 to walk across the bridge. If Bob walks across the bridge, just the nature of his walking to the other side signifies acceptance. What if the argument is raised that there's really no consideration? Well, how can that be analyzed? Well, did Bob have a duty to walk across the bridge at that time in exchange for $10? The answer would be no. Was he obligated at that point to walk across the bridge? If the answer is no, then he's giving up something that he doesn't have to give up. And that's his right not to walk across the bridge. But instead he chose to walk across the bridge, and therein signifies that he's incurring some form of a detriment. How's that a detriment? Well, he could have stayed on the other side. He didn't have to walk, didn't have to use his time or his energy to get to the other side. He didn't have that obligation. Now, was there some benefit that's conferred to the offeror? Maybe. But as long as the offeree especially incurs a detriment, there's going to be evidence of consideration. Let's give some other examples. An agreement not to sue is evidence of consideration. Now, we have just finished our chapters on the court system, litigation, alternative dispute resolution mechanisms. If in a lawsuit a party agrees as a condition of settlement not to pursue continued litigation, that can be evidence of consideration. Giving up the right to pursue litigation to trial is consideration to bind the settlement contract. So if the offer is, for example, to pay $100, and that offer has been accepted to resolve the dispute and avoid trial, then the avoidance of a trial when there's a right to pursue a matter to trial is evidence of consideration. When there is a disputed amount in controversy, so to speak, an agreement is reached to resolve the dispute over the amount owed, then an accord and satisfaction occurs. Now, that's another term And that term is also located within the chapter that you've been assigned for this contract area. So make sure that you understand what an accord and satisfaction means in the context of a dispute. Now, consideration is not present when there is a pre-existing obligation. When one party to an agreement already has an obligation to do something, there's no consideration. There's no consideration. Because what, after all, are contracts? They're agreements made at the present time for some future occurrence. Now, that future occurrence may be the next moment, or maybe the next week, or the next month. But past consideration, or an obligation to do something that is not present immediately or into the future, is no consideration. A pre-existing obligation is not evidence of consideration. Prior consideration, as I just mentioned, is no consideration when consideration was even present in a past transaction. It will not suffice to support the present contract. A promise, for example, to make a gift in the future is not a binding consideration. A gift is just that. It's a gift. For consideration, there must be a bargain for exchange of promises, a bargain for consideration to support the promise that's been extended. The amount of consideration generally is not an issue, but it must be more substantial than an acknowledgement or a statement of some future intention. Even minimal consideration will support the consideration requirement to have a binding contract. That's why you may see in some formal agreements a promise of $10 as consideration. That promise of $10 represents some level of commitment that probably otherwise is not required, and it's a promise to do something which ordinarily would not be required, but that promise can be enforced. Now, the best opportunity to enforce it is to pay the $10 so that there's evidence of that binding consideration, but that will still be an example of stated consideration. And for a specific amount, the best rule of thumb would be pay the $10 so there's evidence of same. Let's talk about the concept that's brought up in your textbook called promissory estoppel. It's really more than a concept. It's a legal doctrine that has been developed over the years. Promissory estoppel, and the root word is stop. Stop what? Stop the promise. Promissory estoppel often is used to prevent a party who has made a unilateral offer from withdrawing the offer after the requested work has been undertaken but not fully performed. Requirements to establish promissory estoppel. 1, there must be a clear and definite promise. 2, the promise expected the promisee to rely, you hear my dog, to rely on the promise. The promisee reasonably relied on the promise by acting or refraining from some act. And the promisee's reliance was definite and resulted in a substantial detriment. The overall intent for promissory estoppel, and I again apologize for my dog, she's a 7-month-old German Shepherd puppy at this point, and at times she gets interrupted, and she's here with me in my office today when I'm putting this together, so you heard her barking. Now I'll continue on. Evidence of the promise is necessary to avoid injustice. That's the overall theory. So let's go back to my example of the bridge, and Ann and Bob, Ann offering Bob $10 to walk across the bridge. Promissory estoppel can be used when a promisee, Bob, justifiably relies on the promisor's promise to his or her detriment. For example, suffering an economic injury. The promisor must have known, however, that the promisee is likely to rely on the promise and did so. Now let's be very creative with my facts scenario. Ann offers Bob $10 to walk across the bridge. Bob doesn't necessarily say he's going to walk across the bridge, however, says, I need to go buy new shoes. Now that kind of implies that there could be a reason to buy the new shoes. That's not necessarily evidence that the promise has been accepted, but there's information that gives the promisor some understanding that there's reliance put into that promise that Bob is considering. If Bob comes back to the other side of the bridge with new shoes, such that he's going to walk across the bridge wearing new shoes, and then Ann, right before he gets to the other side, withdraws the offer, can she do that? The answer is yes. She can withdraw the offer in a unilateral contract before the offer is accepted. How's the offer accepted? By way of his performance. Did he perform before she revoked the offer? The answer is no. But could a court somehow award a value not representing the $10, because there's no contract after all, but some value that avoids the injustice of the situation? I don't know. I suppose an argument could be made that buying shoes or new shoes was a condition so that Bob could walk across that bridge, and maybe a court would offer Bob some type of economic recovery to do so. But maybe not a good example, but one that I thought was creative that might give some application to this doctrine called promissory estoppel. And there's much more information in your textbook to support those concepts and examples. But promissory estoppel is similar in some ways to the doctrine of quasi-contract. In both situations, the court is imposing contract obligations on the parties to prevent injustice, even when there's no actual contract. The difference is that with a quasi-contract, no promise was made at all. By contrast, promissory estoppel occurs when an enforceable promise was made and relied upon, but not fully performed. Let's talk about capacity of the parties. Capacity refers to a person's ability to be bound by a contract. Courts have traditionally held that the following three classes of persons to lack capacity: minors, intoxicated persons, mentally incompetent persons. Those three categories are typical when we look at capacity. A minor can disaffirm the contract, as an example, and legally recover any consideration given to the party, even if the minor cannot return the consideration received. On the other hand, the adult who's contracting with the minor to their own peril or risk is bound by the contract unless the minor elects to disaffirm it. Minors have a right to disaffirm the contract until they reach the age of majority, and then a period that is reasonable thereafter in some settings. The age of majority ends when one party reaches age 18. In most states, 18 is the age of majority. Minors usually cannot be bound to contractual promises unless those promises involve necessities, such as food, clothing, shelter, and medical care. And then even in those instances, there's a question of how much the minor is expected to pay in those contexts. Let's talk about incapacitated or mentally incompetent persons. And again, this goes to the element of capacity. Only when a court has adjudicated, and that's a term we've talked about before in this course, adjudication. Only when a court has adjudicated an adult to be mentally incompetent can that adult lose the capacity to contract. Traditionally, as your authors have indicated, the descriptive phrase mentally impaired applies to adults when the history of medically documented disabilities exists. A court may determine that one was mentally impaired to lack capacity to contract and therefore has the right to disaffirm the contract. In such situations, the contracts are considered as voidable by the person who's mentally impaired. Not void, but voidable. Let me give you another example of the area of capacity. Intoxication. Intoxication may also impair one's ability to contract. Only when there is evidence of intoxication may a court allow that party who was intoxicated at the time of when the contract was formed to later disaffirm the obligation. Let's talk about the term disaffirmance. The legal avoidance or the setting aside of a contractual obligation is referred to as disaffirmance. Disaffirmance may be occurring by implication or by direct action. To disaffirm, a minor must express his or her intent through words or conduct, that is, not to be bound to the contract. After attaining age of majority, the continued use or benefit of the product or service will constitute ratification. Disaffirmance will no longer be available. Contracts that are contrary to public policy will not be enforced. The last element of a contract to be enforceable must not violate public policy. That's the last element: legal purpose, legal objective. That's when there are public policy considerations involved. Contracts that are obviously unenforceable in a court of law because of the illegality aspect, such as a contract to murder someone, cannot be considered as legally binding. Contracts that require commission of a crime or a tort to violate acceptable terms of behavior, public policy, are void. So if the last element involves public policy considerations that recognize illegal objectives, illegal purposes, there is not going to be a binding contract. That contract never was formed because of that missing or defective element. Unconscionable contracts are an example of unenforceable ones. Look at, in your textbook, sidebar 8.7. Other examples may be where covenants not to compete are deemed illegal based on their unreasonability. Now, this has to be examined very carefully and again in context, but a promise not to compete, covenants not to compete, in a given industry for an excessively long period of time, for example, 2 years, 5 years, 10 years, 50 years, may be unenforceable due to public policy. Contracts are unenforceable when there has been fraud or misrepresentation. Fraud involves an intentional misstatement of fact that induces another party to enter into a contract to which they would have agreed otherwise. They would not have agreed to consider. The specific elements that must be demonstrated to enforce the fraud are: 1, there has to be a misrepresentation of fact, not opinion. This is the very best watch ever made. This watch is a Rolex. If the watch in fact was not a Rolex and it's represented as a Rolex, then there has been an intent to deceive by the offeror. When the offeree has relied on that misrepresentation by justifiably accepting the terms of the offer by the offeror. What are the terms? This is a Rolex watch. And if they didn't know that it was not a Rolex watch, then if they paid money for that watch, a resulting injury would occur. Now let's change the facts a little bit and look at it in context. If you're on the street, for example, in Chicago, and someone comes up to you and says, "I've got a Rolex watch for you to buy, and I'm offering this Rolex watch for $10, and you buy it," has there been a misrepresentation of fact? I suppose there technically may have been if the watch indeed was not a Rolex. But you have to consider the context. Let's change the facts. If you go into a store and you're buying a Rolex, and it's represented as a Rolex, but the dealer was really trying to deceive the potential buyer by misleading them into believing it's a Rolex when it's not, then can there be a contract that can be escaped based on fraud or misrepresentation? I think the answer is clear. Yes, as long as all these elements are present. Then the contract is not going to be enforceable. Let's talk lastly about mistakes. Do mistakes happen? Yes. Unilateral mistakes of fact, material fact, are made only by one party. Unilateral means that one party, not the other, has made the mistake. In general, a unilateral mistake does not give the mistaking party a right to relief from that contract. The contract will be enforceable. Now, of course, there's exceptions. And in your textbook, there are some noted exceptions, so do examine those exceptions. When both parties, however, make a mistake of fact, which is material to the contract, either party has the right to rescind the contract. Rescission is a key term that allows the parties to step away from the contract and be placed in their original positions. Other examples of contracts in which mutual agreement is lacking include those induced by duress or undue influence. Duress means force or threat of force, and in some instances, the force may be physical or even economic in nature. And again, this is covered in your textbook. Undue influence, another aspect that affects whether the parties have really intended to agree to contract, occurs when one party is taking unfairly advantage of the other through contract, and that party misuses their position of trust or a relationship or some type of legal confidence that exists. Those contracts are voidable, not void, voidable because of undue influence, which arises when there is a position of trust, authority, or a special relationship. And again, I'll call your attention to your textbook information. A couple last sections before we conclude this almost hour. Oral contracts are valid and just as legally enforceable as are written contracts. Certain types of contracts must be evidenced, however, by a writing to be legally enforced. And then we come to the term statute of frauds. Statute of frauds are legislative enactments whereby certain contracts must be evidenced in writing to be legally enforced. Even though the parties intend there to be a contract and they verbally entered into agreements to carry out whatever their objectives are. For their objectives and the contract to be enforced, it must, in certain instances or categories, be evidenced in writing. And that's to avoid the possibility that fraud may occur in contractual transactions. What are the examples where the statute of frauds requires a writing to exist for the contract to be enforced? Well, that would be contracts involving an interest in land. For example, property. You're buying property, real estate, you must have a contract in writing. Collateral contracts to pay the debt of another. Contracts that cannot be performed within 1 year from the date of the agreement. Or contracts for the sale of goods of $500 or more when merchants are involved. Again, all that's contained in your case, in your textbook. So, long hour, I suppose, but lots of information. Hopefully you enjoyed this slideshow and the narrative. The purpose of these slide presentations, PowerPoint, is to, again, highlight key points within your chapter for your use and your educational purpose only. Thank you, and thanks for your time and attention.